Be ready. Start. There is a fundamental flaw in the first come, first served policy inasmuch as it involves an element of pure chance or accident. In matters involving award of contracts or grant of license or permission to use public property, the invocation of first come, first served policy has inherently dangerous implications. Any person who has access to the power corridor at the highest or the lowest level may be able to obtain information from the government files or the files of the agency stroke instrumentality of the state that a particular public property or asset is likely to be disposed of, or a contract is likely to be awarded, or a license or permission is likely to be given. He would immediately make an application and would become entitled to stand first in the queue at the cost of all others who may have a better claim. This court has repeatedly held that wherever a contract is to be awarded or a license is to be given, the public authority must adopt a transparent and fair method for making selections so that all eligible persons get a fair opportunity of competition. To put it differently, the state and its agencies stroke instrumentalities must always adopt a rational method for disposal of public property, and no attempt should be made to scuttle the claim of worthy applicants. When it comes to alienation of scarce natural resources like spectrum, etc., it is the burden of the state to ensure that a non discriminatory method is adopted for distribution and alienation, which would necessarily result in protection of national stroke public interest. In our view, a duly publicized auction conducted fairly and impartially is perhaps the best method for discharging this burden, and the method like first come, first served when used for alienation of natural resources stroke public property are likely to be misused by unscrupulous people who are only interested in garnering maximum financial benefit and have no respect for the constitutional ethos and values. In other words, while transferring or alienating the natural resources, the state is duty bound to adopt the method of auction by giving wide publicity so that all eligible persons can participate in the process. Our reading of these paragraphs suggests that the court was not considering the case of auction in general but specifically evaluating the validity of those methods adopted in the distribution of spectrum from September 2007 to March 2008. It is also pertinent to note that reference to auction is made in the subsequent paragraph 96 with the rider perhaps. It has been observed that a duly publicized auction conducted fairly and impartially is perhaps the best method for discharge this burden. We are conscious that a judgment is not to be read as a statute, but at the same time, we cannot be oblivious to the fact that when it is argued with vehemence that the judgment lays down auction as a constitutional principle, the word perhaps gains significance. This suggests that the recommendation of auction for alienation of natural resources was never intended to be taken as an absolute or blanket statement applicable across all natural resources, but simply a conclusion made at first blush over the attractiveness of a method like auction in disposal of natural resources. The choice of the word perhaps suggests that the learned judges considered situations requiring a method other than auction as conceivable and desirable. Further, the final conclusions summarized in paragraph 102 of the judgment make no mention about auction being the only permissible and intra-vires method for disposal of natural resources. The findings are limited to the case of spectrum. In case the court had actually enunciated as a proposition of law that auction is the only permissible method or mode for alienation stroke allotment of natural resources, the same would have found a mention in the summary at the end of the judgment. Moreover, if the judgment is to be read as holding auction as the only permissible means of disposal of all natural resources, it would lead to the quashing of a large number of laws that prescribe methods other than auction, example the MMRD Act. While dealing with the merits of the reference at a later stage, we will discuss whether or not auction can be a constitutional mandate under Article 14 of the Constitution, but for the present, it would suffice to say that no court would ever implicitly, indirectly, or by inference hold a range of laws as ultra vires the Constitution without allowing every law to be tested on its merits. One of the most profound tenets of constitutionalism is the presumption of constitutionality assigned to each legislation enacted. It intended to make an assertion as wide as applying auction to all natural resources. Thank you.